Well, we'll get started. Thank you all for coming to this panel 3.6. Glad you're still showing a lot of energy on a Wednesday afternoon. We still have a lot of important topics to talk about yet, including this one on the evidence locker, which is an intriguing project. I'm Chuck Molenberg, part of the Jones Day team, and I have the privilege of introducing the panel's moderator, Alexa Koenig. Alexa is the executive director of the Human Rights Center at the University of California, Berkeley School of Law. I was struck in reading her bio, which you're welcome to read along with the bios of all of our distinguished panelists, by the numerous awards Alexa has received in creativity and teaching and inspiring change. And that's what this summit is all about. So Alexa, we're delighted to have you here, and I will pass the baton to you.
Thank you, Chuck, for that kind introduction. I am so sorry not to be there in person with all of you in Pittsburgh, but very grateful for the conversation we'll be having this afternoon and grateful to participate in it remotely. As was mentioned, our conversation today will really be looking at issues of accountability and increasing accountability for hate speech and genocide, looking both at accountability as a mechanism for future deterrence around wrongdoing, but also as a means of justice. I think one of the challenges that we have all seen in this digital information age is just how ephemeral online content can be. For example, when information is shared on social media platforms and other places online that is potential documentation of domestic crimes or international crimes, social media companies may remove that content for violating their terms of service. The content may also be removed by those who posted it, who may come to regret the information that they've shared. So one of the things that I'm hoping we will have a conversation around today is a lot of the ongoing efforts that have been engaged in to try to figure out how this information environment can not only be a detriment to justice, but also a means for helping to secure it. And very honored to be joined today by our panelists who will be talking a lot about the work that they've been doing to think through how these new forms of information can really help with the documentation, investigation, and ultimate accountability for hate speech and genocide. The perspective I'll bring to this conversation is from my time as a lawyer and also as a social scientist, also as a trained international criminal investigator. Our team at the Human Rights Center at UC Berkeley had the opportunity to partner with the United Nations Office of the High Commissioner for Human Rights on creating a set of international guidelines on how to potentially discover, preserve, analyze, and present in court information that may be shared in online public spaces. That's called the Berkeley Protocol on Digital Open Source Investigations. I've also been working with a colleague for the last 3 years on the psychosocial aspects of the kinds of hateful information that we may find in online spaces and how both professionals and lay people can better protect themselves from some of those negative ramifications. Without further ado, I am very honored to have this opportunity to introduce our panelists for this afternoon. First, I'd like to introduce Dia Chiali, who is Associate Director for Advocacy at Mnemonic. Dia was at Witness prior to Mnemonic, working for a non-governmental organization that trains individuals around the world on the documentation, visual documentation of atrocities. They work on policy advocacy focused on policies that impact the human rights documentation that Mnemonic preserves and verifies, and especially issues of content moderation. Dia has been engaging heavily in multi-stakeholder forums around the growing issue of terrorist and violent extremist content, including the Christchurch call, where they served as co-chair for almost 2 years, and also through the Global Internet Forum to Counter Terrorism. So thank you, Dia, so much for being here today. Second, I'd like to introduce our panelist, Louisa Klingvall, team leader in the Fundamental Rights Unit of the European Commission Directorate General for Justice, who ensures coordination of the work under the Voluntary Code of Conduct on tackling illegal hate speech online. Federica D'Alessandra, who is joining me virtually today, is Deputy Director for the Institute for Ethics, Law, and Conflict at the University of Oxford. She is also Executive Director of Oxford's Program on International Peace and Security, recent co-chair of the International Bar Association's Human Rights Law and War Crimes Committees, currently a board member for the Friends International Justice Initiative at the Simon Scott Center for Genocide Prevention, among other illustrious appointments. Finally, we are joined by Charles Katubi, Professor of Practice at the University of Pittsburgh School of Law, who is also Executive Director at the Center for International Legal Education, Affiliate Professor at the University of Pittsburgh Institute of Cyber Law, Policy and Security, Honorary Professor of Law at University of Durham School of Law in the United Kingdom, and previously a partner in the global disputes practice of Jones Day in Washington, D.C. So thank you for joining us this afternoon. I would love to start by inviting Dia to speak for approximately 8 to 10 minutes about some of the work they've been leading in the area of hate speech, counterterrorism, et cetera. Thank you, Dia.
Great, thank you. And it's great to be here. I'm glad that I have a timer to keep an eye. I'll just start, and I apologize if this is repetition for anybody, but I just want to start by laying out the issue that we're talking about a little bit. So as Alexa mentioned, I work at Mnemonic. We're an organization that is actually finding this content, we're archiving it, we're verifying it, and we're turning it into usable data sets. And when I say usable, I mean we're talking about content that sometimes directly points to who was the perpetrator of a bombing. Were the proper precautions followed in a specific attack, or was it done in a way that violates international human rights law? Who was the police officer who arrested somebody violently at a protest in Sudan? So sometimes we're actually able to put together a story of what happened, and it's something that could be useful for domestic prosecutors in places where there is universal jurisdiction in order to prosecute human rights violations. Sometimes, though, and I always want to make sure this doesn't get lost, what we're doing is preserving digital memory. This is actually where we started as the Syrian Archive. All of the other work that we've done has stemmed from that, and something that our executive director likes to say, and I think it's important to share, is that there are actually more hours of footage of the conflict in Syria than there are actual hours of conflict. And that's something that we want to preserve as Syrians and as memory. So we're talking about content that serves as memory, and it also can serve as evidence. And what we've seen is that particularly since 2017, when YouTube started using machine learning to detect and remove what they determined to be terrorist and violent extremist content, and I want to encourage everybody in the room to see quotation marks around the phrase terrorist and violent extremist content, because we want to call that into question. What we've seen is that since they've started using machine learning, content has come down at a much increased rate than what we saw before. We try to track that by looking at what's in our archives, what are the URLs that we've archived, and what URLs are still functioning, which are still accessible. So we've seen a lot of content come down very quickly, and we've seen different impacts on different kinds of content, in particular, content in the Arabic language. As you heard when I listed these different archives, so we have Ukrainian archive, and they are actually having a different experience than Sudanese archive, Yemeni archive, and Syrian archive in terms of how quickly content seems to come down. Ukrainian content from Ukraine is coming down at a much slower rate. So in 2017, this really felt like a crisis, but it was something that Alexa and many others have been working on for a while. But that's when I think we really started engaging much more with technology companies and saying, hey, your content moderation processes are directly impacting evidence. We need to do something. And the question of what the solution should be has been a very long discussion, and I think we don't have a solid answer yet. That's what we're gonna talk about today. Because what are we balancing? We're balancing the implications of so content's going to come down. That's not going to stop. There's a lot of interest in removing ISIS content, removing Daesh content, all of that. We're going to continue to see the use of artificial intelligence to remove content. And actually in 2017, there was still at some point a human in the mix. That's not the case anymore. Content is coming down automatically. So what do we do? This is valuable evidence. And I'm talking about conflict zones, but Alexa also mentioned this is an issue domestically as well. There was a case, I don't even know how long ago now, maybe 6 or 7 months, with a militia in New Mexico that had a Facebook page that the prosecutor was not able to get records from Meta because they didn't renew their preservation request to Meta. And that content was then deleted. It was, information about what they had been doing in their Facebook page. So it's a global issue, and there's been a lot of different solutions proposed. This is why I engage in GIFCT and Christchurch Call. It really started from the viewpoint of evidence. So very different perspective for many people. So what are some potential solutions? And I'll just run through these and then pass it on. So one thing is that just right now, especially where there are ongoing conflicts, and this has really reached sort of a crisis level, there's so many different people who are interested, obviously civil society organizations like Mnemonic. I shouldn't touch my microphone. Also, as I mentioned, domestic prosecutors, the ICC. Obviously, we have UN investigations going on. So there's all these different people interested in the content. What should we do? One potential solution is that when there is an ongoing conflict, at least to preserve content temporarily, in order to give enough time for mechanisms to be established and where necessary for proper law enforcement requests to be put in. Because one of the issues right now is that for international bodies, even for domestic prosecutors, there can be a lot of difficulty in accessing this content through the sort of traditional ways, the traditional channels. So that's one, is just thinking about preserving it temporarily, not forever and not everything, and with a lot of limitations on how we're determining what should be preserved. Because if you just say, preserve everything from Ukraine. Well, how are they going to decide that? Is it everybody who's posting from Ukraine? Are they going to base it on people's IP addresses, on things that they're mentioning, on where they have, they being social media companies? So that's one piece, is preserving temporarily with limitations in place. Another is just having a reliable channel for these international justice mechanisms. At a minimum, in order to preserve, if they know there's a specific URL that needs to be preserved, that has been taken down, to have some sort of channel to address that. Again, giving them time to go through and do a proper law enforcement request or a proper legal request. We need also appropriate access for civil society groups like Mnemonic. We have a huge capacity for monitoring and emergency preservation. And recently, something we've heard from international justice mechanisms is actually you have a great handle on how to manage this content and how to verify it, potentially more than some of the people who actually need to use the content as prosecutors. However, we consistently have problems with API access. Facebook, Meta, I should say, not just Facebook, Instagram as well, has made it very difficult to access content on their platform. TikTok has no real access. Out of all of the major platforms, I would say Twitter is the one that makes it the easiest for us to do our work. And then there's also the issue not only of just being able to download the content and preserve it, but actually you can't even search a lot of this content. That's partially because of the kinds of solutions that we talk about here, right? About making terrorist content more difficult to find. Well, that means if we put in our search terms perfectly, in perfect format, we still might not actually get all of the content that's been posted. And so we should, maybe there's a way for us to, not maybe, there is certainly technical ways that this could be addressed, but there's not the willingness yet. Now, I think that might be changing. We'll see. Finally, we just want better transparency on content moderation policies and data retention. How long are platforms actually holding on to content after they delete it? Not after a user deletes it, after they take it down. How are they determining what is TVEC? What is the training data that they're using to train their machine learning? All of these sorts of things are things that Mnemonic has been asking for years, other civil society has been asking for years, and actually these different TVEC-related policies, in particular Meta's Dangerous Individuals and Organizations policy. It's gotten a lot of attention in terms of the potential human rights violations and free expression violations that it could be related to. So, you know what, I'm going to stop there because I'm really excited to hear from the other speakers, but I hope that was a helpful sort of introduction to where we fit in and what we think some of the possible solutions could be.
Thank you, Dia. That was a great foundation for the rest of the commentary and also for the discussion we will have towards the end of this session. You made such an important comment about the competing interests that are implicated by some of the decision-making happening in the space around preservation and use of this content. And just to maybe underscore some of them so that we've got them as the basis for later conversation, you know, certainly the access to information as a human right is a huge piece that's implicated by what happens with this digital content. Also, the human right of freedom of expression, both of which would really advocate for keeping a lot of this content up. But also then, of course, the national security implications at the institutional or governmental level, the privacy implications for individuals around what happens with their data and the control or lack thereof that they may have over it, not only for the users who post this information, but all those who may be visible or in other ways implicated by the content that's posted. And of course, then also the intellectual property considerations, which has been a big issue, I think, in conversations around content moderation. With that foundation, I'd love to now turn to Louisa to talk a little bit about what her team is currently grappling with.
Thank you very much, Alexa. So I work in the European Commission, the Directorate General for Justice, and we're in charge of the piece of EU legislation that requires all member states to criminalize hate speech and hate crime based on the protected characteristics, essentially racist and xenophobic hate speech and hate crime. And of course, in this work, I mean, we have to kind of really look at the whole enforcement chain. I mean, first and foremost, we need to make sure that these types of crimes are investigated and prosecuted. But we also need to look at how we can work with the IT platforms to make sure that they remove hate speech content expeditiously. And of course, very important here to note as well that what we're talking about here is content that constitutes incitement to violence and hatred, that under the European Convention on Human Rights is, I mean, justified limitation to freedom of expression. But just as was explained here together, there is a certain tension in these two objectives because while of course we need to make sure that this content is removed, when the content is removed, that could also hinder prosecutions and investigations. So when we are formulating our policies in respect to online intermediaries' responsibility to the content that they host, we have to bear this in mind. And we very recently had an agreement, a political agreement on the Digital Service Act, which will regulate exactly these issues. And it contains a couple of quite important provisions. So firstly, it will require the platforms to, when they become aware of information that gives suspicion on a criminal offense that would threaten life or safety of individuals, they would actually have to inform law enforcement and provide all the information necessary also to law enforcement. Secondly, and while the DSA as such doesn't contain any general retention requirements, I mean, there's no requirement to retain data. And of course, also data retention implies a certain privacy. So it's another interest here that we are arbitrating with. It does contain the obligations to establish a complaint system. So if I am a content provider whose content is being removed, I should have access to a complaint system. And this complaint avenue should remain open for me for 6 months. And clearly, as a consequence, if you are to have an effective complaint system, that means that in the meantime, the content would effectively have to be retained in order that it can be reinstated should this complaint lead to a different assessment by the platform when they remove. But then moving to the topic more on how we can facilitate investigations in the online sphere. I mean, as I said, incitement to racist and xenophobic violence or hatred and violence is criminal in the EU, but clearly these are crimes that are extremely numerous. They are expensive to investigate. More often than not will the law enforcement not know who the offender is. I mean, most people are not, well, some people are inciting to violence and hatred in their own name, but most are not. So unfortunately, this leads to a situation where a lot of these investigations don't, or the complaints don't lead to any follow-up. And this, of course, leaves the victim without any redress and the complete impunity for the offender. And when I came back from Brussels last year, after having attended this summit, I was incredibly impressed by the cyber investigation skills that I had understood existed with a number of research institutes here in the US. And I also even found out that it existed in Europe. So I was sitting down with my team to see, I mean, how can we make these investigation techniques available to law enforcement? And to what extent can it also be made available to civil society that typically are the ones that are in practice dealing with the victim support? I mean, most people that are facing hate speech that do report it will report to a civil society organization that will try to help them, either to have the content removed because it's very offensive to them, or to actually file a report with the police. So we decided to see if there was any appetite with our member states to kind of start a new work stream on this exact topic. And we started in April with a meeting with law enforcement, with civil society, where we started looking at the technology that is already available. We have an agency in Europe called Europol that have a lot of these tools also available, and very important for us to see, and I think Europol has been very well used by the law enforcement arm that is investigating terrorism and radicalization, but maybe not so much by the law enforcement that is in charge of investigating hate speech. So one important angle is to see, are all of these tools really exploited and used to the best possibility. Secondly, we also wanted to create a space for civil society to see what resources are available to them to also help those that come to them to prepare their file before they hand it over to law enforcement. So we are essentially working or starting a work with this on two tracks, because of course law enforcement dealing with each other. I mean, this is already complicated at the European level because these are national law enforcement agencies. But so we are looking at sharing between law enforcement to the extent that is possible, and then a kind of second track where we can also bring in civil society. And of course, all of this work has to be set against a fundamental rights background. I mean, we need to carefully look at questions of ethics, integrity. It's very important that we work with open source. I mean, we're not talking here about using these type of tools in interpersonal communications, but really open source. So I think that this is a very concrete output actually from last year's summit, so that we are extremely happy about. And we are very much looking forward also to see how we can continue working and also having more exchanges with the good work that is done in North America and the rest of the world on this, because indeed I think we have problems that are emerging in the technical sphere and online, and I think we also need to use technology to help solve some of those problems.
Thank you so much, Louisa. And I know you made reference to open source material. For anyone who may be part of the audience who's not familiar with the term open source information, just quickly, what that is information that any member of the public can access online, either through observation, through request, or through minimal purchase. So by request, it may be putting your email address in to get access to information, but it's something that is generally acceptable or accessible by most people. And by purchase, it's usually things like media subscriptions and others that would be relatively nominal. It also doesn't include anything where you need a special status to get access, like a subpoena or warrant. It also doesn't include anything where there may be illegal activity, like illegal forms of hacking, to get access to this data. So most of what we're discussing in this panel is really about that publicly accessible information. So with that, I would love to turn now to Federica D'Alessandra, who I know has been playing a leading role in addressing some of the challenges that both Dia and Louisa have mentioned in their comments, and in some cases working alongside them in those efforts. Thank you, Federica.
Thank you, Alexa, and thanks to everyone at the Eradicating Hate Summit for bringing us together. It's an enormous privilege for me to be part of this discussion, and I too regret that I couldn't be there in person, but I'm enormously grateful that my remote participation could be accommodated. So my take on this issue will focus on potential solutions with respect to only a subset of the enormous amount of data that is available on social media platforms, and that is digital evidence and information that can support judicial accountability processes. And the reason I want to sever this piece of the conversation is that any such evidence, if it is to be used in judicial and especially criminal proceedings, obviously will have to be handled in accordance with specific standard and procedures that preserve its chain of custody and protect its evidentiary value, and ultimately, and most appropriately, should be handled by law enforcement and entities with official mandates to carry out investigations. And they should, of course, work in collaboration with civil society groups so that this information can be preserved, treated, and stored in ways that can, in fact, be used in judicial accountability processes to bring perpetrators, specifically of mass atrocity crimes, to justice. I will also focus my remarks on the international rather than the domestic justice landscape, both because that's where I think the currently we are seeing the biggest gap, but also because this is where I also see the greatest potential. And some of what I will say, it's already been covered in previous remarks, but the first point I want to make is that we don't have yet a clear idea of just how important digital evidence might be to bring in perpetrators of mass atrocities to justice. We're starting to see how this evidence is being used in international courts, but this is a fairly new and still evolving area of practice. But in principle, we do know that digital evidence is important. And based on what we're seeing emerging from conflicts all around the world, its importance, it's only destined to grow, which is crucial, which is why it is crucial that it be preserved. Social media content in particular can help fulfill a number of investigative functions, either on its own or in triangulation with other forms of evidence. It is used as intelligence, lead information, corroboration. It can even play a crucial role in establishing either the so-called crime base, meaning the international, which international crimes are being committed, where and when, or even establishing linkage, which is essentially tying a specific perpetrator to a crime, including by establishing intent and mens rea requirements. And conceptually speaking, we might also distinguish between preservations that social media companies perform in reaction to requests from judicial law enforcement authorities and proactive preservations of content they removed, which is something that I think, as Dia has highlighted, is necessary, but it is challenging because it can only be done in limited cases and under specific conditions that essentially allow them to comply with their overreaching legal obligations, which Alexa mentioned may include obligations under on privacy and data protection law, among others. Suffices to say, for the purpose of this discussion, that of course, social media companies will only be able to hold information that has been removed from their platform for so long. And unfortunately, this time frame is often not adequate for international justice authorities that move at a lower pace, a slower pace than domestic authorities, and also have limited channels to put forward requests for preservation and disclosure. And one may add to this mix of challenges the fact that international justice, the international justice approach to judicial accountability around the world is still piecemeal, in that it's limited to specific conflicts where, for example, the ICC has jurisdiction, or where other international institutions, such as the UN, for example, might mandate an investigative body. And these bodies are often mandated after a crisis has already escalated, and so in response to that escalation, once atrocities have already been alleged. Mandates face a number of challenges in their deployment and operation, including the fact that they're often conferred for a very short period of times that average 12 months. And given international justice processes by nature often take years, if not decades, to unfold, this is left important preservation gaps between the time when the information and evidence is collected and when it might be used at trial. So all these challenges being taken into account, I still think that this is one of the most interesting and promising areas of international justice, because in part due to a sense of fatigue with this piecemeal approach we've seen to date, there seems to be momentum growing for the establishment of an investigative solution that be standing on a permanent basis, potentially conflict agnostic, and able to support and either itself perform investigations into international crimes and mass atrocity crimes, similarly to what the three ad hoc investigative mechanisms that the UN recently established for Syria, Myanmar, and ISIL-Daesh do, which is essentially they're mandated to collect, collate, and preserve evidence in accordance with international criminal standards and build case files for use at trial, whether in domestic or international courts. And this is a proposal that I am proud to say my team at Oxford and I have played a role in advancing, because it's the outcome of a major study that we carried out in the last 3 years in partnership with the UN, with the Simon Scott Center for the Prevention of Genocide, among others. And the case for the establishment of such a standing investigative body and the broader contours of what this could look like are detailed in the report that we recently rolled out, which is called Anchoring Accountability for Mass Atrocities, and is available open access on our website. But at its core, the proposal entails the standing up of a permanent investigative support capacity, which is a technical and operational issue that resonates significantly with most people and constituents involved in establishing such investigative mandates. And this entity would essentially act as a service provider to other accountability mandates with a view to maximize efficiencies, ensure sustainability and existence essentially in perpetuity, and leveraging capacities that already exist to eventually achieve economies of scale. There's a second piece to the proposal, which is that this entity could itself perform and carry out criminal investigations or quasi-criminal investigations, quasi-prosecutorial functions, so to say, when triggered by a competent body, but the where, when, and how of what this trigger should look like, it's proving a controversial issue with some states, which is why ultimately our team decided to approach the proposition by decoupling these two functions. And the reason this excites me and why I'm bringing it up in the context of this discussion is that if such an entity were to be established, even just in its first component, it could go a long way in addressing some of the key challenges that we're currently facing in terms of preservation requests, reaching social media companies promptly and consistently, having liaison, essentially an institutional link between the companies and this body, ensuring that whichever digital evidence is preserved and disclosed from these platforms is put to good use in ways that comply with international human rights and fair trial standards. And most importantly, that an international repository for such digital evidence, or a digital evidence locker, if you will, is created, maintained, and legally protected under international authority. Now, I won't go through the full list of the features that we propose that this entity should have, because the functions and prerogatives that it would have go beyond the issue of digital investigations and evidence preservations. But in terms of our conversation today, it might be helpful to highlight a few of the characteristics that we think these bodies should have, such as an adequate level of independence and autonomy from other parts of the international legal order, including the ICC, but also if this were to be created within the UN from the Secretariat, similarly to essentially what the three existing mechanisms for Syria, Myanmar, and ISIS-Daesh do or have, that it be afforded international legal protections, including privileges and immunities, particularly insofar as the inviolability of their archives and data is concerned, that it be resourced with state-of-the-art technical infrastructure, including the with respect to information management and the security of these digital archives, which is something that the existing UN ad hoc mechanisms have already invested significantly in standing up. And equally, that its core personnel would include, of course, information analysts and OSINT specialists, but also experts and tools for digital investigations beyond open source that could include remote sensing capabilities, financial intelligence, and other forms of documentary technologies. Of course, it would have to include data security and management personnel with technical, including forensic and analytical expertise. And it would be responsible essentially not only for the maintenance and security of these archives while investigations are active, but also importantly at the closure of mandates, given the long time frames that international justice can take. And it would essentially regulate access to its archives in a way that avoids, essentially, even internally, avoids cross-contamination and breaches affecting investigations into multiple country situations. And of course, one of the most important functions that it would also perform would be to have this liaison function, both with prosecution authorities, but also with social media and private sector actors, but also with civil society actors, so that the interests and contributions of all these constituents in the international justice ecosystem can be maximized and duly taken into account. And I will say that, not less importantly, this entity should be given the authority either under existing legislation or with the development of an appropriate dedicated framework to go directly to social media companies to request preservation and disclosure, maybe in a similar manner that some domestic jurisdictions can already do under the Cloud Act. This is obviously a very sensitive political issue, or rather a very sensitive issue properly, and the outcome is not predetermined in any shape or form. Realistically speaking, even if this were to happen, and that's a big if, it might still take a few years to get us there, which makes, in my view, the timing of this conversation especially important, because it both means that we still need to think about proactively about immediate term solutions, but also that we have the chance and the opportunity to shape this proposal in a way that does maximize benefit to all justice stakeholders. I will say, however, that I think the prospects are for this to happen are as good as they've ever been, and this proposal does seem to be gaining momentum. Now, I will conclude by saying that I don't see this solution as the only solution that is necessary in the space of digital evidence preservation. As we've said multiple times, I think in the course of this panel, there are many groups that are working in the space and they're pursuing incredibly important objectives, all of which were in different solutions to the ones that I have outlined. And there must be space for more than one locker model to be pursued. But equally, I believe that it's crucial that all of these constituencies continue to work together or work even more together to holistically advance solutions that can be complementary and essentially that each can tackle different pieces of this very large and complex puzzle. So that being said, I look forward to hearing views, feedback, and especially suggestions about how we can push this agenda forward. And I do believe this is possibly one of the most important challenges facing our generation of lawyers, policymakers, private sector leaders, and human rights advocates. So thank you, and I look forward to everyone's insight.
Thank you, Federica. And a point that I would want to underscore is a really critical one that you made towards the end of your comments about the different reasons and purposes for an international evidence locker or international archive of some kind. As Dia has already pointed out as well, there's certainly a track that is looking at the utility of this information for historical memory and transitional justice related purposes. We have, of course, the purpose that's at the heart of this conversation today, which is international justice and legal accountability, but also the social science needs. So I think a parallel conversation and an overlapping conversation has been the need to really get more information about what digital content exactly is flowing in these spaces and to better understand how people are using this information for both purposes that could be seen as socially beneficial, but also potentially socially harmful, for example, hate speech. And I know there's been a long call among academics to try to get certain kinds of access aggregated or anonymized to be able to give more insights to the broader public around the exact scope of the use of digital information today. With that, I would love to turn to Charles to speak a little bit more and pick up on what Federica just introduced, which is the idea of the utility to which this kind of digital content can be put, drawing on his experience in bringing international claims. Charles, the floor is yours.
Thank you. So, I'll start off by saying here, unlike the rest of everyone else here, I'm not an expert in hate speech and global evidence lockers. So you're probably wondering why I'm here. I spent the last 20 years of my career prosecuting international claims. And I use the word prosecuting there very generally, and that's really the core of what I'm going to get to today. I'm here to sort of deliver the message that the tsunami of evidence, of visual evidence of human rights violations that we've seen over the past few years is matched only by the many, many forums and venues and places and opportunities we have to vindicate these claims. I've heard a lot about, criminal authorities, criminal investigations, prosecutions today. I've heard a lot about, you can read online about domestic criminal prosecutions that have been brought based on visual hate speech that's circulated online. We've talked about the International Criminal Court and how important it is, state-to-state accountability at the ICJ. And all this is terribly important and for the good. But one of the most remarkable innovations of international law over the past 2 decades has been the empowerment of private claims against states and state actors under international law. And I think that's the prism I want to sort of talk about a little bit today. We're at a historical moment where real injustice can be brought to light, not just through eyewitness testimony, but through visual evidence, and not just by states and state criminal authorities, but by private claimants as the end users. You know, victims of human rights violations have a variety of fora at their disposal. The war in Ukraine has given rise to private human rights claims against Russia that have already been filed in the UK. And if Russia gets designated as a state sponsor of terrorism, you're going to see claims here in the United States as well. The European Court of Human Rights remains open for these claims, and I think there's 20,000 of them or so pending regarding the war in Ukraine, and there's going to be more. Underappreciated, and this is a space that I've worked in for many years, is the number of ad hoc arbitrations under investment treaties that can really adjudicate what are essentially human rights claims against states and state authorities for violations against individuals and the representatives of their businesses. And if we're limiting the end users to just state authorities, investigative authorities, international authorities, we're really missing out on one of the important weapons of international law to date. So, you know, if this is what we're also trying to do, and this is sort of the prism I'm looking at this from, I'm going to offer just 4 basic points that I can take from my practice. And one is, Frederica, you've already mentioned this, and this is absolutely true, is international law moves glacially compared to domestic criminal prosecutions, right? The venues and fora where this evidence may be useful may not even be possible yet, not even just on our minds, but possible or on our minds yet. So preserving them for historical memory and for potential use down the line is absolutely critical. I can think of just a sampling of recent cases I've handled, and every single one of them was based on factual events that happened at least a decade ago, several of them 2 decades ago. So that is something we have, but at the same time, evidence disappears in a flash. It's gone. We have to preserve it now, knowing that we're eventually going to put to use down the line. Now, one thing that Federica also talked about that I think is really important is, as we're doing this, is that we have to be thinking about admissibility and how that this becomes probative evidence as best we can. Now, civil and criminal, it's going to be very different. I don't have the time or really the knowledge to go through what is admissible or probative in every area of the law, international and domestic fora, but I can offer a few general principles. I wrote a book on general principles of law and international due process, and I have a chapter on general principles of evidence that are sort of across the board in various systems of law. So I'm going to offer up a few here. First, while video evidence is really important, it carries a lot of weight. I've seen this. International tribunals continue to favor the receipt of evidence by persons with direct knowledge of what the visual evidence is showing. So to the extent that we can collect this video evidence and know who took it and where, it can be incredibly important to an international tribunal because that can be tested by cross-examination. Not necessary, but that is the way to really elevate this sort of evidence from circumstantial and interesting to really probative. It leads to my second point, and again, Frederica hit on this as well, chains of custody. If experts can cast doubt on the authenticity or chain of custody of video evidence, it's not going to be giving a ton of weight by an international tribunal. That's the case in the United States for this sort of evidence. It's the case internationally as well. So, care must be taken as we're developing these sort of online tools to capture the accurate timestamp and ensure no manipulation occurs throughout the lifespan of the evidence. And third, and I've seen this play out in international tribunals as well, is proof acquired by unlawful or improper means will likely be stricken from the record or denied any weight. Where, for example, a party is gaining access to information by cyber trespass or hacking, that is likely not going to take much weight before an international tribunal. That is just the fact. And so care must be taken to be able to present this sort of evidence. Again, who took it, where they took it, the circumstances in which they took it, and the legality of them taking the evidence. And I don't want to get too pessimistic or restrictive here. The last thing I want to say is a bit more optimistic, is that it is a general principle of law that proof can be administered by circumstantial evidence. And this sort of video evidence, when overlaid with other eyewitness testimony of human rights violations, of various violations of law, can really be important circumstantial proof of what you're trying to prove in these sorts of cases. So, base analogy, and here's how I'm going to finish up here, is for the U.S. lawyers in this audience. It's hard to overstate the importance of Section 1983 and Bivens claims in enforcing constitutional rights over the past 50 years in the United States. And we would be much worse off here if we depended solely on state authorities to police that narrow corridor of liberty that we have here in the United States. It's the same internationally as well. As we move forward with these tools, we have to be thinking about these sorts of private claims as end users. We have to be thinking about the needs of private litigants if we are, in the decades in the future, going to be making the best use of it going forward.
Thank you, Charles. I really appreciate your comments, and it's incredibly helpful to know from an evidentiary perspective exactly what can maximize and potentially fight the weight that this information might be accorded in a court. I have been told that we have until 10 after the hour, given the delayed start to our panel. That should give us just enough time to go through the conversation really quickly. I had promised Laura and Amy that we would absolutely mention any deliverables that will be coming out of this conversation and the work that we are doing independently and collectively. And I also want to make sure that everyone has a chance to either respond to some of what they've heard from the other panelists or to even ask a question of it. I would just ask that we try and keep each final comment to about 2 minutes, given the temporal constraints on our session. With that, Dia, since it's been a while since we've heard from you, would you like to kick us off with some final thoughts and deliverables?
Sure. I wish I had more time to scan my notes because there was so much in this discussion. And I have to say, it's really great to be sitting in a room with folks that I haven't heard from before, because I think that really underscores one of the points, Federica, that you made. We do need to have, there are a lot of different discussions. There's a lot of different stakeholders. And so I think one of the final points that I would make is just, we have to keep talking with each other. We have to integrate these different perspectives, and it's okay to have multiple overlapping solutions. And in fact, that's the only way that it will work. And so I'm always excited to hear about, I'm very excited about the standing mechanism proposal. And it also doesn't, it doesn't address, for example, our API needs. But that is a separate conversation that is actually just it's sort of shoring up the other discussion. So I think that's also been maybe one of the most exciting things just in the last few years, is how much different stakeholders are starting to talk to each other. We're getting different people in the room. We've actually managed to get different companies in the room with each other, which can be very difficult. So yeah, maybe I'll just end it there by saying I think that we are in a really exciting moment, that we are talking to each other and engaging with each other much more than we ever have before. This conference is a part of it. And certainly if there's anybody who's been listening online or anybody in the audience that can think of somebody who maybe should be part of the discussion but hasn't been, please, we all want to be connected. And we are, these discussions are continuing in so many different forums. So I'm just excited to see where things go. And I am also excited, especially over the next year, just to work on these sort of immediate temporary solutions. They're Band-Aids, but a Band-Aid can still do a lot, and it's important. So yeah, just an honor to be here and really great to hear from everyone. Thank you.
Thank you, Dia. Next, I'd love to hear from Luisa. Any final comments on deliverables or in terms of responses to what you've heard today?
Yeah, no, as I said, we will kind of continue working on this particular work stream that we started after the conference last year. And just to echo, I think it's incredibly important that we keep a very open conversation on this. There are a lot of interest at stake in this area, sometimes conflicting, and I think it's very important that we surface them and that we are aware of them and that we discuss them, because I think we're all kind of coming from this also from a very rights-based approach that needs to sit at the very heart of the steps that we take to move forward.
Great. Thank you, Luisa. Federica?
Yes, Alexa, before I say anything else, I want to apologize to everyone in the audience that the lighting, that it's become very dark here in the UK just over the past hour, and I clearly did not plan my lighting, but hopefully you can still hear me. And I just I guess to second what DM and Luis have said, I think it's important that these conversations continued. I am enormously encouraged by just the diversity of perspectives and the enthusiasm and the willingness really that seems to be there across the board. Some groups and actors more than others, but I think that there is a realization that this is a very important issue and that these conversations have to continue moving forward. One deliverable, well, two deliverables, I guess, from my perspective would be to continue building on the work that my research team and I in Oxford are doing in terms of continue to build support for the standing up of a permanent mechanism. And particularly in the next phase of our work, we want to move from vision to implementation and really try to get granular in terms of what building blocks might look like to make this operational, to make it become a reality. And the second deliverable, which is no less important, is a report that we're actually working together with Alexa and the Human Rights Center, and that is building on some of these ongoing conversations to which Dia also has been participating with many others that will provide I think an overview, a helpful overview of some of the main challenges that we're confronted with when it comes to the preservation of social media evidence, particularly in support of criminal prosecutions, and also set out maybe a vision and a few propositions in terms of where we can go from here. So this is a space to watch.
Thank you so much, Federica. Charles?
Yeah, I'll rely on the others here for the deliverables. But the one thing I think that comes out clearly here is the need for all of us to be pulling on the same rope. You know, it's easier when you're talking about domestic issues. So you have the issue of police brutality. Whether you have a set of actors, identifiable set of actors, one law, maybe two, state and federal, a set of courts you know you're going to go through, an avenue that is clear for this issue. Here you have dozens of people in dozens of jurisdictions with dozens of fora, with dozens of different ideas and different standards, and the risk is that it all splinters. And we see that in international law generally. You can have various people, dozens of people working on the same thing in different ways. And I think the key here, because this is so nascent, overlaid in a field of law that is so nascent, that we do need to keep everyone together and realize we're all working towards the same thing. And the more talking that happens, I think, is all for the better.
Thank you, Charles. So then maybe I'll just close by reiterating and underscoring a few of the things that I've heard from all of you today in terms of next steps. What has definitely come through clearly from what I've heard is the multiplicity of roles that need to be fulfilled. So certainly with the social media companies themselves, the need for a clear channel of communication that has the ability to make legitimate preservation requests, to potentially help coordinate and communicate whether there is a conflict agnostic mechanism created or some other conduit for the preservation and potential sharing of this information for legal purposes. Second, thinking through a complaint mechanism. So if the information is brought down, what are the opportunities for individuals to challenge the deletion or silencing of their freedom of expression in these online spaces? Of course, for civil society groups who are continuing to experiment, to iterate, to be incredibly creative in thinking through both identifying the gaps in what's currently happening or the challenges, and brainstorming ways to potentially work through them. As Dia mentioned, I think we really need to be broadening that conversation, and the more perspectives we can be bringing into it at this point to make sure that we're not missing critical considerations through the human rights lens, I think is paramount. There's a critical role also for lawyers to play. We need to understand the legality of some of what is being proposed and get some clarity on ways forward. There are obviously conflicts of laws when you're working across different jurisdictions that I think can be very challenging to overcome in terms of carving a path forward. But they are ones that, the legal community certainly can be tasked with helping to think through in order to ensure that we have lawful preservation, chain of custody, and mechanisms for building cases. Finally, for academics to continue to do the kinds of research that is really needed to figure out the gaps in our understandings, but also how this information can potentially be useful for seeking some form of justice. So with that, I want to thank all of our panelists so much today, and also for the kind introduction an hour ago. I look forward to the deliverables and to working with all of you on next steps. Thank you so much.